quick to leave the podium. Professor Bendor, would you like to join us? Thank you, Judge Marcel, for those wonderful comments. Thankfully, our session on judicial activism versus judicial restraint is not over, because we have an opportunity for questions and comments from the audience, including, I believe, Mr. Harper, am I correct, that the co-presenters can raise questions of the panelists as well, and of each other perhaps. So please feel free to share any comments with us. Yeah, Mr. Hollingsworth. Professor Hollingsworth, I'm sorry.
I was wanting to ask not only the panelists, but anyone else who might be inclined to think of this. Everyone here, of course, well knows that in the United States, both in the 30s, during and after the Lochner Court, and then in the 60s, during and then after the Warren Court, there's been much jurisprudential hand-wringing about judicial activists versus judicial restraint, which goes on even to this day, and even qualms about judicial review itself, going back to Marbury v. Madison, which in our system started all that. And I don't mean this at all as a chauvinistic question, but because the answer may be none or not at all, but I'm wondering if, to what extent any American legal thought had any significant effect on the similar kinds of issues that you've both spoken to today.
Well, as I told, I think the problem is not an Israeli problem. I think this is a universal problem, and also an American problem. And I was trying to say that we shouldn't think about the rulings of the court if the rulings are activistic or self-restraint. The problem is whether specific judgment is true, whether the Constitution is interpreted in a justified manner. And I think that normally, I'm not a dogmatic person, that there can be circumstances, quite rare circumstances, where court can think about the judiciary. But normally, the court or people thinking about the judgments of the court should not think about what the court have done, but about constitutional law, whether the constitutional rule is true, is correct, is justified. And I think this is the right question, not thinking about the judiciary, thinking about the law.
I would just add, answering your question, that yes, indeed, there is a significant influence by American thought and American case law on the Israeli debate about activism and passivism. But the following question would be, isn't it overly influencing the Israeli debate? And not because the American debate is not of importance, of course, it's extremely important, but because, as mentioned earlier, the reality in Israel, the legal framework, the way the constitutional structure of Israel is actually done is absolutely different. And also the tradition is different. So what we are experiencing quite often is that the American critique of judicial activism is imported directly into the Israeli debate, but not necessarily is that critique relevant in all terms. For instance, if one compares the Israeli Supreme Court not only to the American Supreme Court, but to some European courts or constitutional courts, one would come to a conclusion that the Israeli Supreme Court is extremely passive and not activist at all. So, answering your question, yes, there is an influence, not necessarily always at the right context.
Just relate to the question and maybe offer another perspective from Israel to the positive answer that was already given. So I would even enhance it and say that the first Israeli decision on judicial review of legislation was very much inspired by Marbury versus Madison in terms of the legal technique, because once again, it was not something expressly written into the law, but rather inferred from the superiority of the constitutional text. And when these comparisons are made these days in Israel, and when sometimes even the supporters of the court say, well, we are doing just as our American friends are doing for more than 200 years, so there are sometimes counter-arguments say, well, but we don't have exactly the same system of nominations of judges. Maybe we should have hearings for, I would say, candidates to the Supreme Court just as they are held here, because we don't have them. So I think that this spirit of comparison is still very relevant even for nowadays debates on the role of the Supreme Court in society in Israel.
I'll also just chime in and on sort of the European experience. And my background is that I'm raised in Germany and did my legal education in Germany. And I think that debate, and I think you may have actually referred to the German Constitutional Court in Europe. I think that debate doesn't happen for a number of reasons, right? I think one of them is the selection of the courts. One of them is the political system not being polarized in a way of two parties, but rather a wider sort of bouquet of ideas, at least being formally entrenched in society. And then, specifically with the German Constitutional Court, it is simply the institution in the country that has the most, that always garners the most respect amongst the political, amongst all constitutional branches by a wide margin. The second one's the police, believe it or not. But the Constitutional Court has always been seen as somewhat above the political fray, and I think this is one of the large differences between the US Supreme Court and the Constitutional Court in Germany, that it is to a certain extent above politics. Now, make no mistake, one Constitutional Court judge single-handedly rewrote the entire tax system in Germany at one point. And there was, to a certain degree, a debate about that, but it never reached sort of this climactic discourse that it has.
Does in Germany, if I can ask, is there a significant controversy between judicial activism and judicial self-restraint? Is this relevant to the German discourse, legal discourse?
My read is no, right? It's not, and I think there has been. I wouldn't even say, if you want to, I wouldn't even characterize the German court as being very restrained about it, but it very much was able to argue in constitutional and very unpolitical terms. I think this notion of becoming overly politicized, the court many times, not always, and couldn't, because of subject matter, but try to stay away from that. The fact that it's also located where it is, not in Bonn at the time or Berlin, helps it. It's sort of sitting in the province. I grew up 25 miles away from that, so I'd say self-deprecating manner, but I think that helps, right? And there was a debate about moving the court to Berlin, and that was very roundly sort of rejected very, very quickly after reunification.
Yes, I'm afraid I'm about to ride one of my side horses, but it seems to me that we use Marbury as an innocent symbol in an extraordinarily misleading way. That yes, Marbury involves the very act of the Constitution, but it's a remarkably trivial and important act. And if you combine Marbury together with a decision that's never taught, that is a week later, Stewart versus Laird, which involved the Jeffersonian purge of the Federalist judiciary, which had been placed there politically in order to sign the Jefferson takeover, the Supreme Court capitulates. And the importance of Marbury, and putting the allegation aside, is that ultimately Marshall does not engage. He denounces Jefferson, but he does not engage in saying you have to give Marbury the commission. So from one perspective, it is judicial abdication. I mean, if you take seriously the notion that William Marbury has a right to his commission, then the Supreme Court says, don't come to us for any relief. The truly activist decision is McCock versus Maryland, in which the court upholds the bank. And I think this is relevant to the point that I apologize for this one made it, that most of Justice Barrack's decisions upheld of the state. Now, is that activist or restraint? It all depends on ultimately your own view of the policy, your own politics. The result in McCulloch was not particularly controversial. That's something to build. The opinion was wildly controversial because Marshall basically turned upside down the notion of a limited government assigned powers and basically go ahead to the national government to do whatever it wanted. So it seems to me that one has to distinguish sometimes between the result in a case and the opinions, and then the historical influence of an opinion. There are lots of opinions that die and have no particular influence, even if the results hang on. And then there are opinions that really inform. And I think McCulloch is one of those opinions. Ditto with the 1926 opinion of basically saying that Congress should never focus on the Commerce Clause, which is an issue this very day with regard to the constitutionality of the health bill. So it seems to me that Marshall is remarkably activist, but not in Marbury's Madison.
Well, I want to change the focus, if I may, to do this. I appreciate the presentation, both your presentations. Thank you for it. But I was particularly struck by Yigal's closing statement, which you made
It's a quote.
And the question I have is a little unfair, and I apologize. It's unfair because I should ask this of Justice Barak, but he'll never answer it. So I'm going to ask you, Yigal. You must have thought about it. What should he have done, but didn't do?
I can't obviously answer the question instead of Justice Barak, and I don't know if you might answer it later on today. No? Perhaps.
But I meant sort of reflecting back on his career. What was the thing that he should have done?
I didn't say these words in any. No, thank you for the question. I didn't say these words in a critical vein. Yeah, I think, but I think I don't know what Justice Barak's answer would be. But I think the answer to this should be measured on the results, more to speak. And I think Justice Barak would like very much to see after his retirement that the Israeli judiciary stands independent and is not subject to the type of attacks that we were experiencing. So I cannot point out a specific decision that should have been decided differently, but I think that the outcome after so many years of the Israeli legal system should have been, and it's of course not Justice Barak's fault whatsoever, but it should have been that the Israeli judiciary would find itself in a better place, more independent, having a clear status within an entrenched constitution, and not subject to some of the attacks or ideas of narrowing its power, as we have seen over the last years. The answer whether being more activist would lead to this or being more restrained would lead to this, I don't know. But perhaps history would answer this better.
Professor Weinberg, I might add that Justice Brock will have a chance to respond on
His answer will be probably much better than mine.
Maybe until the evening he will agree to answer the question.
He's scheduled at 4 o'clock.
I just wanted to raise 2 points for either or both of you to comment on. One is that it seems to me the measure of one measure of activism in terms of public perception would be the public reaction to cases, and also the government's reaction. And there's been a lot of news in the press about the government not responding to court orders. I wanted to comment on that. Another thing, instead of thinking of activism as a reflection of counting cases, to focus on some of the very controversial cases that President Barack cases that would have equaled ground of education in the United States many, many times. So I wonder whether the issues that came before him, the issues that could come before him, the openness of the court litigation, meant that there were decisions that were made that, in the context of Israel, were actually very controversial and therefore might well as a difference.
Well, I think not all judicial decisions, but I think a lot of judicial decisions which is against the government, against the will of most of the public, are not popular, and there are a few decisions of Justice Barak of the Israeli Supreme Court as a whole that are not popular, not because these decisions are not true from the legal point of view, but because the public or a lot of Israeli citizens doesn't like the consequences of the judgment, and they believe that the court ruled due to the personal political views of the judges. And I think that what should be done, I don't know how to do it, but something has to be done that the public and the justices themselves has to understand that the personal political views of the justices are not relevant. And there is a constitutional law, and at times I agree with a specific judgment, although from my political personal point of view I don't like it. But this is the law, and I think that until now, this is as we understood, this is not the situation in Germany, but both in Israel and in the United States, most of the public, also the lawyers, believe that justices rule what they think is right under the personal political views, and this is the problem.
I would just add that from what I have learned, that the problem of not definitely or not always respecting the court's ruling is not. First of all, it's not an Israeli problem. I'm not sure it's a problem within Israel at all. If it happened, it's very rare. The court is respected. The court's rulings are respected. Supreme Court rulings and other courts as well. But around the world, in Austria and in some European countries, over there the problem emerged lately, and there is a debate over what can courts do if they should do in order to make their rulings enforceable and enforced by the other branches. I would also add that I think that coming back to Barak's writing and the role of a judge in a democracy, so the two major roles, the one of protecting the Constitution and the other one of bridging the gap between law and life. When a judge bridges the gap between law and life, that's one of the means to reduce the chance of non-enforceable judgments. Quite often you might find that an unenforceable or unenforceable judgment would be a judgment that is non-activist, but a judgment that is staying with the current state of law and unwilling to adapt the law to the reality. So if we are in a panel of activism and of passivism, not necessarily the passive judge would come up with a ruling that will be later on enforced. Sometimes the active judge would do a better job in this respect.
Let's take one more question before we get to break. If there is a question. Professor Bidwell, did you have any response to the judge's last comment? Did you have any response to the judge's last comment?
Of course, there's always some gap between the law and the reality. But as I said in my presentation, the judges have to think about reality. They normally, not dogmatic as I said, but normally they don't have to think about the judiciary. They have to think about law. They have to think about reality. They don't allow to think about themselves, about the judiciary. This is the normal situation.
I want to thank our two panelists who are now scheduled. Mr. Hoffman, am I correct for a 15 minutes?
Yeah, about a 10-minute now.
Okay. How about if we convene at 10:30 and for our next